mode.
Hello and welcome to our March 2018 Expertise in Business webinar series. I'm Eric Hobbs, President of Technology Associates, and I'll be your moderator for today. So today's topic is a continuation, part two in a series of three, and today we're going to talk about avoiding the pitfalls of worker classification. So we're delighted to be joined again by Mimi Sewell from Sewell Employment Law, located here in Raleigh. Mimi's firm works with companies in North Carolina with 100 employees or less, and she provides employment law and human resource compliance advice, prepares employment-related contracts, and defends employers against employment-related claims. So first, some housekeeping. If you have questions, enter them into the chat box, and I'll forward them on to Mimi. And our next webinar is going to be on Tuesday, April the 10th, and will be the final webinar in this three-part series. And that webinar will be focused on the employee exit. So if you want to register for that, you can go to www.technologyassociates.net/registration for more information. So with that in mind, we'll cover real quickly what we're going to go over here. So a couple things we're going to touch on, important things when it comes to wage compliance, how the classification of employer contractor is determined, which was very insightful, and I learned a lot when we went through our practice on this. Some distinctions between the employee and contractor legal tests, how to determine between an exempt and non-exempt employee. And before this practice webinar, I thought it was just whatever we wanted it to be, but apparently there are rules around that. And what are the most common employee exemptions? So without further ado, I will bring on Mimi. Mimi, take it away.
Thanks, Eric, again for having me. I know sometimes these topics aren't fun to talk about, but except for folks like me. So I very much appreciate you inviting me to chat. I want to start with just a basic overview of why I personally believe that wage compliance should be every small business owner's, or I mean every business owner, but especially small business owners, kind of primary primary topic that they need to put on their task list to review. And the reason is, unlike a lot of, the reasons are, I should say, unlike a lot of employment claims, and usually we business owners think of employment claims as wrongful discharge matters. And unlike wrongful discharge claims, wage violations or complaints that we haven't paid wages correctly, those actually can lead to personal liability for owners or decision makers that have sort of the authority to make decisions about wage payments or classifications. So the fact that there is personal liability that our corporate status doesn't protect us from is concerning. So the other piece to it is joint employer liability. So a lot of small business owners work with temp agencies or staffing firms, and what often can expose us as a client of those staffing firms, what can expose us to liability, is if wages are not paid correctly by the staffing firm or the temp agency, we as the client can also be held liable for those wage violations. And then the last piece that I think is very important is, unlike, again, a lot of employment claims, there really isn't any insurance coverage that we as business owners can purchase that will cover unpaid wages. There is a particular insurance policy called Employment Practices Liability Insurance. That particular type of policy generally protects businesses from claims of wrongful discharge based in discrimination, as opposed to claims that we haven't paid wages correctly. Sometimes there are provisions in those types of policies that might cover research in terms of figuring out if wages have been paid correctly, but there generally is not coverage to cover any alleged unpaid wage. So the fact that there's personal liability, potential joint employer liability, and then no real insurance, net to catch us, I think wage compliance can be a significant risk that we just aren't thinking about on a regular basis as business owners. And if you'll move to the next slide, Eric, generally the primary risks are if we don't classify someone correctly, and we either classify them as a contractor and they're really an employee, or we classify them as an employee but indicate that they are exempt from overtime, and we do that incorrectly, the primary risks are, that we haven't, if they're a contractor, we haven't paid taxes correctly. If they are misclassified as an employee, then really the issue is unpaid wages. If we haven't paid overtime correctly, if we've misclassified as exempt. In addition to those things, if they find, they being the Department of Labor or the IRS, if they determine that we've misclassified folks, intentionally to avoid either paying payroll tax or overtime, then there are potential penalties, and that is determined on a case-by-case basis. There's also an issue of paying either taxes or wages late. So there can be interest charged on those late payments. And then additionally, for misclassification as a contractor, in addition to payroll tax, there's also unemployment taxes on the state and the federal level that could be due. And finally, one piece that's not listed here on my slide, but one piece for unpaid wages, if they find that we, again, have done it intentionally, then they can determine that there are double penalties. So, for example, if they claim that we haven't paid unpaid overtime and it's $5,000 of unpaid overtime, they can automatically double that as a penalty. So instead of $5,000, we now are dealing with a $10,000 debt.
Actually, I've got two questions here that came up on this last slide. First off, you mentioned joint liability, joint employer liability when it comes to like temp staff, that type of thing. So does the same thing apply if you are part of a PEO, like a professional employees organization?
Yes, it can apply in that position as well. What I would suggest is for any of you that work with a PEO or work with a staffing agency, that your little homework item should be to go back and look at your contract with those entities and determine if there is clarity on who is responsible for any kind of wage violation. Also look for indemnification language. You want those staffing firms or the PEO to indemnify you if they make an error with respect to wage payments.
And one other question here. So how far back can somebody go to claim that they weren't paid incorrectly? So I guess the question there is really, if I have an employee that works here for 5 years, can they claim that, hey, they were misclassified the entire 5 years?
They can, but generally speaking, the Department of Labor and the IRS will only go back 2 to 3 years. So generally, they'll only look back in time 2 years. If they find that they believe that we've done it intentionally, they have the right to go back 3 years. So 2 to 3 years, they'll look in the past.
Got it. Okay.
Great question. Great question. All right. So now that I've hopefully got everybody's attention, and I don't mean to scare anyone, it's just these are items that most folks aren't aware of. But let's talk about generally the wage and hour laws that likely apply to most businesses here in North Carolina. So most of you have heard of the federal law, which is the Fair Labor Standards Act. And this particular law, as most of you know, establishes things like the federal minimum wage, federal overtime pay requirements. It also discusses exempt, non-exempt classifications, things like record keeping, and many other things. This is just sort of a highlight. Importantly, I want to explain essentially who has to comply with this federal law. So if you are an employer that has an annual revenue of at least $500,000, then this federal law applies to you. If you are a hospital or a preschool, elementary, or secondary school, then this, regardless of your revenue amount, then this law applies to you. Even if you're a small business owner that doesn't meet those two bullets, your employees can still be covered by this federal law. and it's this last bullet. If you have employees who are in any way involved with interstate commerce, then those employees have the protections of the Fair Labor Standards Act. So let me just briefly talk about interstate commerce. So it seems like a complicated concept, but in reality, it's a very broad concept. So the easiest way to explain it is to give a few examples of how broad the concept is. So if any of you have employees that perhaps order supplies, just regular office supplies for your business, or you may have an employee that unpacks those boxes of supplies. They may not be the one ordering them, but they unpack the boxes. If any of those supplies are ordered or delivered from outside of North Carolina, then those two employees are involved in interstate commerce. So it is a very broad concept to such a degree that almost all employees are given the way we currently conduct business in this day and age, are likely going to have some involvement with interstate commerce and will be protected by the Fair Labor Standards Act. Can we move to the next slide here? All right, so kind of more importantly, here in North Carolina, regardless of whether you're controlled by the Fair Labor Standards Act, all employers in North Carolina that have at least one employee have to comply with North Carolina's Wage and Hour Act. And North Carolina's Wage and Hour Act essentially tracks the federal law, so it tracks the Fair Labor Standards Act, and then adds additional obligations. So think of the Fair Labor Standards Act, for those of us here in North Carolina, the Fair Labor Standards Act is the floor. That's the basic requirement that all employers would have to meet. And then the North Carolina Wage and Hour Act provides additional requirements. So the Wage and Hour Act is going to cover similar things that the Fair Labor Standards Act covers: minimum wage, overtime, record keeping, exempt, non-exempt. It's also going to cover specific things like when we can make wage deductions, when we have to pay for travel, how we can pay our employees. So, for example, in North Carolina, we can require that all employees are paid by direct deposit. In other states, you may not be able to require direct deposit. You may have to offer employees the option for a live check. And then, of course, the North Carolina Wage and Hour Act establishes things like when we can pay employees. So, for example, here in North Carolina, as long as we pay everyone on a monthly basis, then that complies with state law. Other states, however, have requirements that you pay, twice a month or, every week. So North Carolina state law tracks the federal law but adds additional requirements. Eric, can you move to the next slide? All right, one other law I want to mention that often gets ignored, and that is the Retaliatory Employment Discrimination Act. It's a mouthful for me, so I'm going to refer to it as RETA. And the reason I bring up this particular statutory act is that it gives employees the option, under certain circumstances, to file retaliation claims under state law. So there are several specific options or situations where an employee can file a claim under this act, but I've pulled out sort of 4 of those that would apply in an office-related setting. So, and the one I really want to focus on is the last bullet. So if an employee makes any sort of complaint about how they are paid. Now, this is not complaints, that they want to get paid more. I want to raise. It's not what I'm talking about. This is a complaint about how they're paid. So if someone comes to you and says, I don't think that my overtime was calculated correctly, or I don't think that I'm classified correctly and I've been working 50 hours a week and I think I'm entitled to overtime. So it's that sort of complaint. It doesn't have to be anything formal. It can simply be a question that's presented to someone who operates in an HR role at your company. It also, this protection also attaches even if we review the matter and we determine that their paycheck is correct or the way that we have them classified is correct. Regardless of whether we've done anything wrong, the fact that they have made a wage complaint puts them in a new protected status. So if they are terminated or disciplined after making that complaint, it gives the employee the option to file a retaliation claim under RETA.
And this is really where proper documentation comes in handy, right? Because if you've talked to somebody about some sticky issue and you haven't documented it, then they come back and say, hey, I wasn't being paid right, then you're kind of stuck with it.
Absolutely. So I'm in no way saying you can't discipline or terminate based on other reasons, but you're absolutely right, Eric. So if you've documented the actual reason that you're terminating or disciplining, and it has nothing to do with this wage issue, then that documentation becomes your primary, the basis of your primary legal defense. Absolutely.
But I think that comes back again, and I stress it to being on the up and up, because if somebody's late 3 times in a row and you don't say anything about it, then they make some claim, get protected, and you fire them. You even though you fired for a reason, it still looks a little suspicious since you didn't say anything when the events occurred.
Absolutely. Absolutely. That's why, you hear HR folks yell, document, document, document. That's the legal reason to have all that documentation, is to defend yourself against these types of complaints. All right, so let's talk about a few legal tests. So the first thing we want to talk through is when you have a worker and you may want to work with that person as a contractor, a 1099 contractor, as opposed to a W-2 employee. And often the reason for that is that either the worker comes to you and says, I want to work for you, but I want you to pay me on a 1099. Or we may say, which is easier for us, to pay you as a 1099 as opposed to W-2. And what I want to, and we'll talk about this, I think, in a little bit more in just a few minutes, but I want to talk through the basic test. So most of you have heard of the IRS 21 factor test. And this is the primary test that we think of when we talk about this issue of control. So the IRS 21 factor test was actually expanded by the IRS into three detailed sections. So it's more than 21 questions now, but it's essentially the same concept. So the 3 sections are behavioral control, financial control, and then they've sort of got a catch-all bucket that says, what does this relationship look and feel like? So when we think about behavioral control, this is, are we as the business trying to tell the worker when they have to work and how they have to work on a day-to-day basis? So are we giving them office hours? Are we reviewing their work and giving them feedback on a regular basis? Are we training them on how to perform the work? That's the type of behavioral control. Financial control has to do with, are we as the business covering all of the expenses, whether we pay that directly or we reimburse it to the worker? So it's things like, are we covering the cost of that worker's physical space, so where they need to actually sit and do the work, their office area? Are we covering the cost of any equipment or software or supplies or resources that they need in order to perform the work for us? And then the final piece, relationship. So this really has to do with 2 primary things. Is the relationship ongoing? Meaning I am engaging this worker to provide services for me, and there's no time period. So I'm just going to engage them ongoing into the future until one of us terminates the relationship. That is very similar to what we call at-will employment. At-will employment with a W-2 employee is, I'm going to hire you today, but there is no promise of any specific employment, or there's no promise of any employment for a specific period of time. And so that is, so if you engage a contractor on the same terms as an at-will relationship, then the IRS is probably going to view that more like an employment relationship as opposed to a contract relationship. The other piece to this relationship bucket really has to do with how we hold that worker out to the public. And if I am a member of the public, am I going to assume that that worker is an employee of the company? So think about things like, am I putting that worker on my website? And on my website, am I putting them in the same bucket or describing them in the same way as I describe my employees? Am I giving them a job title, for example? Do I give the worker business cards with my company logo on it? Or do I give that worker a t-shirt to wear with my company logo on it? So am I holding that person out to the public in a manner that looks and feels like an employment relationship? So that's the basic control test. And if you guys want the specific test, it's on the IRS website. And Eric, if you'll just let me know if people want the link, I'm happy to send that out or send that to you to send out.
Yeah, and I've got one question that's come in, and I've got another question that came up on what you've talked about, and I've seen this before because we do a lot of marketing and intelligence with small businesses in the area, and I know of a couple off the top of my head where they have a fractional or a part-time CFO that's listed on a couple of different people's websites as their CFO, in their leadership.
Mm-hmm.
And in that situation, clearly that person's working for a couple of different companies, probably under a 1099. And what you're saying here is because that company's holding them out as a sole employee, that could be a little dicey.
It could be, but one thing to keep in mind is when we look at the relationship between the company and the contractor, we have to look at it as, kind of at a 30,000-foot view. And so one factor won't necessarily control. And in this case, I think it kind of takes us in, which is great, takes us into the next bullet here, and that is, if the worker is actually providing similar services as a 1099 for other businesses, right, then that's a good thing, right? Because if the worker, if you as the business are just one client of that worker, then that means that worker is actually running their own business. So if that in your scenario, if that individual who's working as a CFO for multiple different companies part-time, and then your business is one of those companies, then more than likely you could make a very strong good faith argument that working with that person as a contractor is appropriate and reasonable.
Got it.
Because that CFO, right? Because that part-time CFO is actually running their own business, and you happen to be just one of their clients. And so, in that scenario, if you do list them on your website as your CFO, that's just one factor in this full test. So
one factor is not going to trigger it. You got to look at all of it in total.
Absolutely, you got to look at that relationship kind of from a 30,000-foot view. You've got to look at it sort of from beginning to end, the whole relationship, not just one piece of it.
Got it.
Right. So, and importantly, one factor one test that we often forget about is here in North Carolina, the test of whether or not someone's classified correctly is not just this IRS control test. The IRS control test is actually just one factor. In North Carolina, the test is the economic realities test. And it's a 6-part test, and I've listed the basic 6 questions. And unfortunately, we don't have time to go through them all in detail. But the crux of this test is exactly what Eric just brought up. Is the worker building their own business? If the worker is only working for your business, so in Eric's example, if that individual is only working for you as your CFO on a part-time basis and not working for anyone else, so if they're only working for you, then that's probably going to be a problem under the North Carolina Economic Realities Test. And if anyone has, follow-up questions on that test, I'm happy to respond. But we've listed the 6-part test. I'm, again, happy to provide a link with more information on the economic realities test.
So one question that came in on when you document employee complaints, does the employee have to sign or acknowledge the document? So I guess the question is if you are reprimanding an employee, do they need to sign or acknowledge it?
So in a perfect world, everybody, in a perfect world, whenever you discipline an employee or counsel them on anything or communicate with them on something, whether it's discipline or not, you want to document what you've discussed and have the employee sign off on it. Now, they don't necessarily have to agree with what you've drafted or prepared, but you want them to at least acknowledge that you spoke to them about it. So as many of you are aware, often when you are disciplining an employee, they're not happy. And so they are sometimes not inclined to sign anything. And we can't force them to sign anything. So in that scenario, we want to still complete our record, our written record. And so our practice should be, if an employee refuses to sign, that on your documentation where you have the line for the employee's signature, that you as the management level person should write in that space, employee refused to sign, and then you as the manager should sign and initial that. And then on that documentation that you have, there should be a space for the manager or management level person to sign that documentation as well. So you as the manager should sign off on the documentation and date it. And then even though the employee has refused to sign, we now have a complete written record. So from a legal defense standpoint, I want to see a complete legal record. And, as long as you've initialed in the space the employees refused to sign, we've still got evidence that we sat down and attempted to communicate with the employee about that issue. Great question. All right, so once we have determined whether the worker is a contractor, a 1099 contractor, or an employee. Let's assume in our hypothetical world that we've determined that this individual should be a W-2 employee. Our next classification decision is, are we going to make them exempt or non-exempt? So exempt means that the individual is not eligible for overtime. Is not eligible for overtime. So what I want to start with is just kind of a general framework. And the general framework pieces are this. And if you guys don't take anything away from this webinar, please take away this first bullet. And the first bullet is salaried, and paying someone a salary does not necessarily mean that they are exempt from overtime. Paying a salary is often one element of an exempt position. So we'll talk through what those exemptions are here in just a minute, but just remember that salary does not equal exempt. Second bullet, to determine an exempt status, it's really a review of each position and then specifically on the individual working in that position. So it's a case-by-case analysis, and you really need to not just look at the position as a whole, but you want to think through how the individual working in that role is performing. And we'll explain that again here in a minute. And then the final bullet, guys, is my rule of thumb. And this is what I talk to all of my clients about, and that's this. When you're making a classification decision, starting at the beginning, I want you to start with the premise that all employees are non-exempt and entitled to minimum wage and overtime unless they fall under an exemption allowed under state or federal law. So all employees are non-exempt unless we can reasonably argue they fall within an exemption. And to be exempt, employees must meet typically a salary requirement and the duties requirements of an exemption. So most of us just focus on the salary, but we also need to think about the duties requirements. So when we think about exemptions under federal law, Fair Labor Standards Act, and the North Carolina Wage and Hour Act, there are several that we commonly refer to as the white collar exemptions. These are 6 exemptions that generally apply in an office-related setting. So we're going to go through each of these very briefly. We could probably spend an entire session on 1 or 2 of these alone. So if you guys have specific questions, let me know. So let's talk. So there's the first one is the executive exemption. Now, as most of you are aware, there is, for many exemptions, a salary requirement. And that was, of course, in the news quite a bit in the last year. The salary requirement has remained, at least for now, at $23,660. So to meet the executive exemption, you have to pay the employee a salary of at least $23,660. In addition to that salary requirement, the employee's primary duties also have to be that they manage 2 or more full-time employees. Now, this could be full-time equivalent. So, for example, you could have 2 employees that are both working full-time, 40 hours a week. Or you could have 4 employees that might work 20 hours a week. So as long as that employee manages 2 or more full-time employees, they'll meet that particular requirement in the exemption. The second piece is, to meet this executive exemption, the employee has to either manage the business or a division in the business. And the division doesn't have to be anything formal. For example, this could be someone who manages your accounts payable, accounts receivables department. And they manage the accounts receivables person and the accounts payable person. So it doesn't have to be a formal corporate division. But as long as they meet the salary and the duties requirements, then they could be an exempt executive. The second bullet is the professional exemption. And again, typically there is a salary requirement, the same amount, $23,660. Generally, the professional exemption is going to apply to folks who are like myself, doctors, lawyers, some nurses, engineers. These are folks who went to school for a significant period of time, and you have hired them in order to essentially learn from their intellectual work. In addition, these folks have to have some amount of discretion and judgment in terms of making decisions that impact your business. So the professional exemption generally is going to apply, again, to folks who've been to school for a significant period of time. The administrative exemption, this is probably the one that's the grayest of all the exemptions, and the one that probably gets abused the most. The one thing I want you to take away from this is the administrative exemption does not apply to all of your administrative staff, regardless of whether you pay those folks a salary. So the easiest example I can give is, most folks think that if they pay a receptionist the $23,660 salary, that they'll fall within this exemption. This exemption applies to a much higher level person. So a receptionist would not fall within this exemption, but perhaps a CFO would, or an accounts payable or accounts receivable manager would. So essentially, this is an exemption that covers an employee who performs office work that's related to your business operations generally. That could be, business operations could include things like accounting, marketing, human resources. It could include things like quality control, those types of things. Any primary function necessary to operate your business. The other key piece here, and this is why a receptionist doesn't fall into this exemption. So an employee under the administrative exemption has to be able to exercise, quote, discretion and independent judgment with respect to matters of significance. So maintaining a calendar or answering phone calls isn't going to get us to discretion, independent judgment in matters of significance. This is really going to apply to more significant issues. So let me give you a simple example. You've got, and I keep going back to accounts, but it's often the simplest concept in an office setting. So let's say you've got someone who works in your accounting department, and they're the ones that handle things like collections on past due amounts owed by patients or customers. If this person has the ability to negotiate collection payments or settle collection amounts, then that's probably going to be sufficient discretion, judgment, and any determining money owed to the business will likely be a matter that's of significance to the business. So the administrative exemption, in addition to that salary requirement, requires that high level of judgment and discretion. Eric, can you move on to the next one?
Well, and I think the thing to hammer home here is, we see it, where if you've got somebody who's simply answering the phone at the front desk, even though they are an admin, so to speak, they're not, can't be exempt under this rule. There has to be some, some matters they're dealing with that they have some input into or discretion with.
Absolutely.
Got it.
Absolutely. So this is a higher level employee than someone working in a receptionist type role or a traditional secretarial or admin data entry type role.
Got it.
You're absolutely right. All right, the next three are a little different. So these three don't necessarily require that salary basis, so that $23,660. So here are those three. There is an outside sales employee exemption, but the key word here is outside sales, so outside. This does not apply to someone who works in an inside sales role. So what I mean by that is, think about, a 1950s encyclopedia or vacuum salesman that went door to door and sold products. So that is essentially what this exemption would apply to. Someone who is meeting with customers or patients outside of the office on a routine or regular basis. And their role is to sell either company products or services, and they earn a commission based on their sales. So for this particular exemption, you don't have to pay a salary basis. You can pay them on full commission. You have a lot more flexibility with paying how you pay this person as long as they meet that outside sales duties requirement. The second bullet, and Eric, you could probably talk more about this than I could. The second bullet is a computer employee exemption. So this is for folks who work as a computer systems analyst, a computer programmer, or a software engineer. It doesn't necessarily apply to anyone who might manufacture or repair hardware. But if they meet this sort of basic description in the exemption, then you can either pay that employee that $23,660 annual salary or more, or you can also pay them on an hourly rate basis, and the exemption indicates that it has to be at least $27.63 an hour. So the last bullet is kind of a catch-all. So if you've got, and usually this is, of course, going to apply to a higher level, C-suite level management individual, but if you've got someone who performs some version of office work for your business, and they don't necessarily meet all of the duties functions in either the executive, professional, or administrative exemptions, but they may meet one of those duties requirements and one of those exemptions. And you pay them in some fashion at least $100,000 a year, and part of that $100,000 is a regular salary of $23,660, then that person could be an exempt, highly compensated employee under this exemption.
So we've got a question about a specific job classification for a physician, but I think you've got a slide that covers a lot of those kind of unique positions coming up here shortly, right? So we'll just sideline that for just a second.
We do, and if there is
this is it.
Oh, here we are.
We're here.
Here we are. If there are specifics, everyone, and specifics about, a particular role that maybe is a little unique and creative, then what we probably want to do is talk offline to go through that in detail and walk through, where there could be some exposure. But generally speaking, we pulled together a few common medical office positions to give you an idea of where these folks could fall under an exemption.
I tell you, before we launch into this, I've got two questions that kind of fell from the last slide. Can I go back real quick? Okay, so the first question is obviously the exempt versus non-exempt is factors in obviously some overtime, right? So what kind of protections can you have in place for a non-exempt employee and overtime? In other words, and we had this situation a while back where a guy just kept working overtime, and it's like, all right, well, can you prevent them from doing that? What's the rules there?
Right. Great question. So if you have a non-exempt employee and you're going to, you want to regulate how much overtime they work. Really, as an employer, all we can do is create a written policy that basically says all overtime has to be approved by your supervisor or your manager or the office manager, whatever that traditional role is, whoever manages that employee's time. And once you have that policy in place, then if the employee violates the policy and works unauthorized overtime, we can discipline based on a violation of the policy. Now, a key distinction here, with or without that policy, if an employee works overtime, whether it's authorized or not, you are required to pay them for those hours. So what the policy does for you is it gives you the ability to discipline based on a violation of your policy. Now, Eric, do you remember if you'll scroll back through the slide or through the presentation back to the RETA slide in the beginning?
Whoops.
So here it is.
Here we are.
The forward one. So remember under RETA, if an employee makes a wage complaint about overtime and we discipline or terminate, then it gives the employee the option to file, or the ability, I should say, to file a retaliation claim. Well, here's where our written policy comes in to protect us. If we don't have a written policy in place that says the employee has to obtain permission, then if we discipline based on working overtime that wasn't authorized, they can allege retaliation. If we have a policy in place, it makes their claim really hard to prove because they should have known that they had to seek approval before working overtime. Does that make sense, Eric?
Yes, that makes perfect sense. So a couple more questions. An accountant working 50 to 60 hours a week during tax season, receiving comp time instead of overtime for hours over 40, earning less than $50,000. Is this exempt or not?
So a couple things. An accountant, and I'm assuming a CPA,
not a CPA.
Not a CPA. All right. So some accountants, even if not CPAs, can fall under the professional exemption, but that is on a case-by-case basis. If they fall under the professional exemption, then it doesn't matter how many hours they work. If you pay them that $50,000 salary, that meets the salary basis requirement. So it wouldn't matter if in tax season they work greater hours and outside of tax season they work less hours. And whether or not they fall within that professional exemption probably plays into, again, how much education that they've gone through. So I'm happy to talk offline about that. The other piece I want to mention here is this concept of comp time. So comp time is not something that private employers can provide. So typically when we think of comp time, it's almost like instead of paying the employee for overtime, we're going to provide them with essentially a paid benefit like accrued vacation. And that type of arrangement is only allowed by, in North Carolina, if you are the state of North Carolina, so if the state is your employer, or a municipality. That's not allowed for a private employer. So if you have if you have a scenario where an individual is non-exempt, they don't fall into any of these exemptions, and they are entitled to overtime, we cannot provide them comp time in lieu of paying the overtime hours. Even if the employee asks us for that, we're not allowed to do that under state law in North Carolina. So if you have an employee who in tax season is working overtime, then and they don't fall under this professional exemption, then you would have to pay the overtime hours as opposed to comp time.
Yeah, we ran into that too. Some of our project guys who work, they may have a big project, work 60 hours in a week, and we're like, okay, well, we'll give you 20 hours of PTO in your account, so to speak. And yeah, we were told, no, you can't do that by our PEO. So I had to kind of rewrite and restructure some rules around how we did that.
Absolutely. There are some other creative ways. So if you have folks who have a flexible schedule. So sometimes they work 20 hours a week and sometimes they work 60 hours a week, depending on business demand. Then there are some other creative ways to reduce overtime exposure. And essentially you would define their work week as a 60-hour work week. And so your salary that you're paying them would cover that full 60 hours, and the 40 hours of overtime, the 20 hours of overtime that they're working, we can reduce that overtime rate a little bit on an ongoing basis. So if anyone has questions about kind of creative ways when you've got folks that work like accountants or CPAs that work, in particular seasons, a lot more hours, there are ways to reduce overtime exposure, even if they're non-exempt.
Another question, and then we'll jump into the distinctions for medical office common positions. The question is around the judgment of in matters of significance. It seems gray. And so there's an example here about someone who's an outreach coordinator who can't make decisions on their own, but can suggest. Right. But they can't bind the organization to anything. So is that a quote unquote matter of significance?
Right. So first of all, you guys are absolutely right. All of these tests are all gray. And I wish that there was a bright line, black and white option. The best we can do is determine if we have a strong and good faith, reasonable argument that we've classified the position correctly. And the way we do that is we look at the actual exemption test, and we look at, sometimes there's guidance from the federal government, the Department of Labor, and these are called opinion letters. Sometimes there are opinion letters that might not be directly on point, but somewhat on point. And then we also can look at cases and how judges have looked at certain positions. So as long as we can look at those three pieces of information and look at our classifications and say, based on our review of all three of those resources, we feel strongly that we've classified correctly. So that's the best we can do with all these gray legal tests.
But I think a lot of it comes down to kind of their decision-making authority, right? So if you're doing, outreach, and you're trying to renew members, and maybe you're able to give them some discounts or, kind of change the service as you go, then you've got some discretion and independent judgment there. If you're just calling to say, hey, how's your membership, then probably no discretion there, right?
Right. So in this particular example, what it probably comes down to is how, when they make that suggestion, is that suggestion typically followed? So for example, in a lot of these scenarios, we may have an employee who may not have the ability to make the final decision. and they have to basically make a recommendation or a suggestion to their boss or their supervisor and say, here's what I think we should do. And the boss has to ultimately sort of say, yes, let's do that. In that type of situation, it doesn't necessarily mean that the employee does not have significant discretion and judgment. So it typically comes down to when that employee makes a suggestion, is that suggestion typically followed by the supervisor, or does the supervisor kind of go, okay, thanks, and then make their own decision, using the supervisor using his or her own discretion and judgment? So I think that is, again, a gray answer. And guys, I'm sorry, I wish I could provide a black and white yes or no answer. But it really comes down to the decision-making authority and whether it's not just passed on or whether it's actually acted upon by the person with the final decision-making authority.
All right. Hope that answers the question. If not, chime back in here. So before you get into this, the question that applies to this that I've been kind of holding in the kitty for a minute, if a medical company has a contract with another company to provide a physician, can that physician be paid 1099?
All right. So I'm assuming that the other company in this scenario is like a staffing firm.
Yes, probably.
Or a temporary staffing firm. So if you are working, so if your practice has a contract with a staffing firm to provide a doctor, and in that scenario, typically the doctor is going to be an employee of the staffing firm. And so you would pay the staffing firm according to your contract with the staffing firm, and the staffing firm would pay the doctor wages as a W-2 employee. Now, if that other company is just a recruiting firm, so that other company is just recruiting the doctor on your behalf, and then they hand the doctor to you and they say, do you want to hire him or work with him or her? And then you pay that other company a fee for finding the doctor for you. And typically that fee is based on what you are likely to pay that doctor within the first year. So that is not a staffing firm. That's really more of a recruiting firm or a recruiting service. In that scenario, the relationship with the recruiting firm has nothing to do with whether they're a 1099 or a W-2. Once you bring them on board, you then have to determine, are they properly classified under those legal tests as a 1099 contractor or an employee? So Eric, can you go back to my original slide at the very beginning on contractor versus employee and the IRS control test? Okay. So take forward one. So guys, this is where you would have to look at that relationship with the doctor. And are you telling the doctor what the hours are and how to perform? You may not be training that doctor because you're hiring him, expecting him to, or her, to know how to, provide the medical care that you need them to do. But if you're basically giving that doctor office space, all the equipment and resources he or she needs, including, nursing and administrative support. And if you are, if that doctor is only working for your medical practice, as opposed to that doctor working part-time at multiple other practices, then more than likely this particular doctor is going to be a W-2 employee and not a 1099 contractor.
And plus to dive just a tick deeper here, regardless, even if you are contracted with another company, that doesn't insulate you from liability if this person isn't classed properly, correct?
Right. So we go back to this concept of joint employer liability. So in that scenario, if the doctor is actually an employee of the staffing firm or the temporary agency, then if that temporary agency makes an error about how to pay the doctor, so meaning if the temporary agency says we're going to pay the doctor as a 1099, and that's that's a misclassification, then both you and the temporary agency can be potentially liable for unpaid wages and taxes owed. So absolutely.
All right, let's go through these here, if you would.
Okay, got it. All right, final slide. So in again, guys, this is really only relating to common positions in a medical office. So generally speaking, if you employ a doctor, they are more than likely going to be an employee and fall within the professional exemption. With respect to a PA, in a lot of scenarios, a PA is also going to fall within your professional exemption. And really, like we mentioned before, where they may or may not fall within the professional exemption often has to do on that level of education. And it's kind of a case by case. We have to look at guidance from the Department of Labor, and then guidance coming out of case decisions. Registered nurses, guys. Registered nurses are generally going to fall within a professional exemption as well. Now, the distinction here, and those of you who are working in medical offices probably understand this distinction a lot better than I do, but licensed practical nurses, sorry guys, there's a typo there. Licensed practical nurses are not often included in a professional exemption. And I think the distinction here is that a registered nurse can provide many services that a licensed practical nurse cannot. So things like, I think that the registered nurses can actually prescribe medications and that sort of thing. A practice manager or an office manager for a medical office, often that person wears multiple hats. And so many of you on this webinar probably fall within this bucket. But because that practice manager and office manager wear so many hats, and generally they have significant authority to make decisions, whether it's managing people, they serve in an HR role, they handle the hiring and firing for the practice. So because they wear so many hats, they often fall within the administrative exemption. A billing or collection manager for a practice, and I've mentioned this one specifically, because they typically have the ability to determine whether they want to, how they want to resolve a collection matter, or if they want to negotiate an amount down or agree to some sort of payment plan. Because they have so much discretion generally on handling those types of issues, they often are going to fall within an administrative exemption as well. And then finally, one key position that I wanted to mention is a lot of technician roles. So medical technician roles, generally speaking, are not going to fall under any of these exemptions. So most folks that work in those types of roles have gone to school for a short period of time to learn that particular skill. So they're probably not going to have the level of education necessary to push them into a professional exemption. So most of your medical technician roles are going to be non-exempt. Now that doesn't mean you can't pay these folks a salary. You can, but even though you pay them a salary, they are still entitled to overtime if they work more than 40 hours in a work week. So before we jump off, and I know we're right here at time, I want to just kind of summarize very quickly. So the exemption piece, whether you classify someone as exempt or non-exempt, this is a test that you need to go through and determine on the front end, so that once you've started employing someone, you don't have to go back and make that decision later on. Because if you convert folks who have been paid a salary and try to convert them from exempt to non-exempt and start asking them to track their hours, often it creates, one, questions about why you are asking them to track time and why you haven't been paying them overtime previously. But two, often it's a matter of employees find that when you ask them to track their time, it's almost a trust issue. So they feel that you don't trust them if you've never had them track their time and then all of a sudden you ask them to. So again, in a perfect world, we want to try to establish these exemptions on the front end when you bring on new folks. On the contractor versus employee classification issue, one thing I want you to take away is that's not a choice that we have as the business or the worker, that we have to go through the control test under the federal guidance, and we have to look at that economic realities test under North Carolina law as well. And we want to make sure that we can meet both tests in terms of how we classify. In any scenario, on the contractor piece, the safest option is to work with folks as W-2 employees, because if you classify someone as a W-2 employee, then there's no concern about payroll taxes or unemployment taxes being paid to the government. And there's less of an issue about unpaid overtime if we employ them as a W-2. On the classification, exempt versus non-exempt, the safer choice, if you can't make a clear argument under any of the exemptions that we've walked through, the safest option is to employ someone on a non-exempt basis. That way, at least, we're tracking their hours, and if we ever need to convert them to an exempt employee, then it's a much easier conversion from non-exempt to exempt than the other direction. So if anyone has follow-up questions or wants any of the links for further information that we've mentioned, just let Eric know, and we're happy to send that out.
So two quick questions here, I hope. So the first one is just clarification that it's really the person in what the person's doing and not the role that's classified as exempt or non-exempt. And I'll give you an example. If we've got like customer support engineer, I can't just say the position is exempt. I have to look at each individual and what they're doing in the position to ensure that they are exempt. Is that correct?
Right. The reason I say it's a case-by-case basis is if we look at the role and we determine that the role itself, as we've described in our job description, is exempt. Often when we hire folks, we make changes based on that employee's ability. And so let's say, for example, we've hired this person and we believe this person is going to fall under the executive exemption. But when this employee starts working for us and we realize quickly that this person is really not able to manage people effectively. And so perhaps we don't have him or her managing 2 full-time folks. We only give them 1 person to manage. Well, in that scenario, if we've made any changes to that particular role because of the way the employee works, then it can actually pull them out of an exempt status.
Gotcha.
So we just have to we have to just pay attention to any time we go outside of our general descriptions where we've classified the role as exempt, but the employee working it maybe isn't meeting all of their requirements.
Got it. And then the last question I've got here is okay, so how does this normally come up and bite you? So obviously, if you have an employee that complains or feels like they're not classed properly, they could bring that issue up. But does like the Department of Labor or anybody like that look at this every once in a while, or what's the risk there?
Sure. No, great question. So on the contractor employee classification piece, generally that's going to come up in two places. One, on the IRS website, there's a very easy form. It's called an SS8 form, and the employee can simply fill out this form asking the IRS to review whether or not they are classified correctly. So if that happens, then the IRS sends the business owner a notice and asks the business owner to defend the classification decision. So that's one way it comes up. The second way is often when we employ folks or work with folks on a 1099 basis, individuals don't understand what that means, and so when we terminate that relationship, those folks sometimes will go and file for unemployment benefits. So the Division of Employment Security in North Carolina has now developed a new, I don't want to call it a division, but a new group that does investigations. And often those investigations are triggered on contractors filing for unemployment benefits. On the exempt, non-exempt side, there is a potential for a Department of Labor audit at the state level or the federal level. And I am seeing an increase in random audits, although I would not say that anyone should be worried about a random audit. Often, Eric, as you mentioned, on the exempt, non-exempt side, where you see that come up the most is when you've got an employee that is upset. And when that employee is upset and we discipline them or let them go, then often the easiest thing to do is to file a complaint. And those complaints are very easy. They don't cost the employee anything to file. So generally speaking, that's when most of those types of issues pop up.
Got it. Cool. All right. Any other questions from anybody? All right, so a couple things. First, Mimi, thank you so very much for bringing this info. It's great info, and I know I learned a lot. And I wanted to also remind everybody that the next webinar coming up is going to be our last part of the series, our three-part series with Mimi, and it's going to be about the employee exit, so how to handle terminations properly. So for more information, go to technologyassociates.net/registration. And we hope to see you there. So once again, thank you so much, Mimi.
Anytime.